Hello, everyone. This is Rhonda from the Fair Housing Council of the Capital Region. And this is our bi-weekly discussion about housing issues that we call Ask the Counselor. And joining us again is our Executive Director, Claude Phipps. And thank you, Claude, for joining us.
Thank you again.
And we're going to go on and ask some questions that we normally would find ourselves answering as counselors in the Fair Housing Council of the Capital Region, and just share information, have a little discussion to give you some guidance and a little summary of some of the information that we share with the public. So we can start with one of our common questions, and today let's talk about emotional support animals. A lot of folks now find that emotional support animals are useful for them to assist with their mental health issues and are comforting, and and their doctors find that they are a very good therapy for them. But when you're talking about a rental, sometimes, especially if the landlord has what they call a no pet policy, they can have some issues and some conflicts with the landlord. So we want to talk about that today and a couple other issues. So I have my first question for you, Claude.
Okay.
Let's talk about this. My landlord refuses to allow my service or emotional support animal. What are my rights?
Okay. So, emotional support or service animals are basically covered under both state and federal law. You have even if it's in the lease that you cannot have an animal there. If that emotional support animal was prescribed by a medical physician, a medical practitioner, physician, psychiatrist, and is certified, okay, you have a right to have that animal. It would be considered discrimination. Your options would be basically you could appeal to HUD or under Fair Housing or PHRC, okay, because it's known as a disability, and you have a right for that support animal because you have a legal reason and a medical reason that you're basically considered to be I won't say okay, no, I'm just trying to put this the right way. You have a disability. That's what it is. So you're covered under disability acts. Okay, so just you can't outright say no, the animal has to go, you can't have it. Okay, you've got a legal right at that point in time. So your landlord will, if he goes to court, he's going to lose. Okay, you could appeal to the landlord. You could ask. You could show him his certificate, any certificates you have governing the animal, and any letters from a physician or a psychiatrist or any medical representative. Okay, that's enough to get you past any legal issues he may have, and you're protected then by the laws of the state, Pennsylvania, and also by federal law. Okay, so you cannot be discriminated against, and it's treated as though discrimination if a landlord says no.
Right. Normally, we'll see in a lease that the landlord has a no pet policy or a no pet clause.
Right.
And what we always like to say is that a emotional support animal or a service animal is not a pet,
That's right.
so to speak. They are there to provide a service for the individual, so they are covered under
they're protected by law.
Right, they're a protected class under disability.
Yep.
So, but sometimes we get conflicts. Now, a landlord is responsible for the health and safety of all of their tenants.
Right.
And we did have a case one time where a landlord had concerns because he had a property that was specifically set aside that had a no pet policy, no animals, no pets. And he had a building that allowed pets. He had two different buildings, right? So the tenant understood that there was a no pet policy, no animal policy in the building that he was about to rent a unit in. But then eventually he was prescribed an emotional support animal, an ESA. Now, the tenant that lived next door to him or on the same floor had a pet dander, animal dander allergy that was pretty severe. So, whose rights come first is what the landlord was concerned about. And how can he negotiate this if neither tenant would like to move? They want to stay in their unit. They were very nice places, and so the Pennsylvania, you mentioned PHRC, the Pennsylvania Human Relations Commission, pretty much gives the guidance that hopefully as adults we'll be able to work these kinds of issues out, because both the tenants do have rights in this regard, and we want to make sure that our neighbors are comfortable and taken care of, and have peace and enjoyment of their property without them getting sick. Most landlords are interested in that also, if they're decent landlords, and that will take some negotiation and some cooperation amongst neighbors in that case.
Right. One thing is something like that, the two tenants can get together with the landlord, and what could be workable is to provide some type of air purification system to the one tenant that has the dander issue. The landlord, depends on what the cost, and they're not expensive. You have portable systems now that can clean the air relatively quick. It would be something that if it came in front of me, I would say that's a negotiation. Let's see if we can basically work to yes, both parties. Okay, you don't want either party to move. Either party likes the place. So for mitigation purposes, let's see what we can do about the air itself. And again, the one that has the issues with dander, if it's just air, if it's airborne, then the air purifier could basically correct that. If it's not one for touch, not to, basically, if you can't touch, you're not supposed to touch the animal, or you'll get a rash or something, that's more under your control. What landlord's trying to do is say, from an air standpoint, I'm going to help clean the air so that you don't have a problem with it. You don't get not infected, but you don't have a reaction, negative reaction, a respiratory reaction. And you could also, the person who basically has the emotional support animal, he may ask them to help defray the cost. You both want to live there, okay? That's how you negotiate it. You both work to yes. It may cost you an extra $25 a month, okay? Because they're not that expensive, but are you willing to help foot some of this, some of the costs? And if he says yes, then you basically get an addended amendment to your lease, basically saying, I'll cover a portion of this cost because I need the animal, okay? I'm not asking a lot. Landlords, you may also have to support it to put something on the table. The person who has the dander issue, this is how we're going to remediate this. This is our remedy. Now, I hate to say it, I hope this is acceptable. Again, both parties are working to yes. Right. Okay, so that's how we handle that.
And that's a good point. You mentioned control.
Yes.
We have questions sometimes about the animals and the owner's control over the animal. So just because you have a emotional support animal or a service animal doesn't mean that you can just let the animal do whatever it wants to do. This comes into play a lot of times with cats.
Yes.
And cats like to roam outside, and normally you don't see a cat on a leash.
No.
What is the tenant's responsibility to keep the cat away from other residents who may have an allergy or may have a phobia or some other issue, or just don't want an animal walking up on them unexpectedly or at all, really. So Control is also normally a requirement
Prerequisite,
when
yes,
you
yes.
have a
Motion
ESA or a service animal.
Yes.
Always
It's
it is the tenant's responsibility.
and it has to be able to maintain control over that animal at all times.
Right. They
Okay.
cannot go to the bathroom wherever they want to on the property, and you think that you're going to be able to get protection under disability. No, you are still required to have control over the animal.
Yes.
And what they are doing at all times.
At all times. Okay, and that's
Right.
critical.
Mhm.
Okay.
Yeah. So let's go on to before we move on, let's talk about, you mentioned cost and cost sharing.
Mm-hmm.
Now that is different than saying I'm going to charge you a fee
No.
because of having this animal. That's not allowed.
Right. It's not.
Right.
You don't charge an additional fee behind the animal, but this is negotiation.
Mhm.
Okay. Because again, you could also put this person in a building that allows the animal allows for animals and separate them. But again, they want to stay where they're at. Both parties want to stay where they're at. So let's work for the yes. The yes. Let's share the cost. Okay. I'm not going to fine. It's not a fine. You're not paying for the animal, but we have to incur a certain amount of cost to basically make sure that your emotional support animal does not affect another neighbor.
Right.
Okay, so we're trying to make sure that you can get what you need, and another neighbor is not going to be impacted by this decision. And that's the key, is that your emotional support animal cannot affect other neighbors, impact other neighbors. Okay, there's certain you have certain rights. That animal has certain rights, but if you're in an area where somebody's they're allergic to it, they have allergies. Okay, that's an effect. Okay,
Right.
Okay, and we always say health, safety, and welfare. That's what we're always looking at all times. Health, safety, and welfare. The landlord, as a tenant, as anybody, and that's what the law is going to look at. Health, safety, and welfare. We're going to take that into consideration. That animal could be causing discomfort to someone else. How do we mitigate that? Well, we mitigate that by saying we can clean the air. Both parties agree to it. Now, could you share the cost? And
I would imagine it would need to be a reasonable resolution.
Yes.
And
yes.
a reasonable cost sharing.
Yes.
Specific to the need of the other tenants within that building.
Correct.
Right. And the tenant that needs the animal.
Right. And I'd actually both tenants, basically the person who's having the allergic reaction. We allow this, but you need to also contribute something too. The unit will be okay. The air purification system is in your space, but there's some costs associated with it. Maybe you're paying for the electricity to basically run that, so you're not impacted. Because if it's an electrical unit, it's going to be plugged in. It's going to be running 24/7. You're going to incur costs on that. That's because you need to be able to eat that cost.
So all of these things are on the table for
Yes.
discussion between adults who are, trying to be able to live comfortably within the units that they're paying for monthly.
Yes.
And the other question that we sometimes get is, okay, I submitted my document saying that I need this animal from my healthcare professional.
Mm-hmm.
But the landlord didn't accept it. It wasn't enough information. So the question comes up, how much information about the need, my disability, do I need to provide to the property manager or the owner so that they can understand why I need this?
When in doubt, specificity. I hate to say that, the more information you can put, and your healthcare provider can put there, that won't violate HIPAA rules.
Right.
Okay, and you got to be careful, because that information is going to be disseminated. It could be disseminated to the person, other people inside, in your property manager, other people inside that business. Specificity, much information you can put down to justify your case. Okay, because again, if that medical official says yes, then in his mind, what brought you to yes? what did you use to make that decision? If it's a psychiatrist, again, they have to be able to put that down and state in writing.
Our position at the council is normally that is not for the counselors to decide.
Right.
That's between yourself and the property manager and
The tenant.
the physician.
Right, and the physician, right, because
Right.
again, you've got HIPAA rules that'll be involved there, and we
Right.
don't want to run afoul of the HIPAA rules, okay? And they're
that's-
very close. Healthcare officials will not disclose information. If in doubt, they will go to, I call it the silent mode, okay? Deaf and dumb mode. They will not give the information out. And the property manager, he can have a right, but then from a property manager's standpoint, I would send back a letter with the stated questions that you need to have answered. Okay.
Right, and most property managers do. They give the tenants their own form for their physician or their healthcare professional to fill out, and the healthcare professional will, to the best of their ability, without violating the patient's HIPAA rights,
right.
will fill it out and hand it back in. Now, whether the landlord accepts it or not,
Then at that point in time,
you
you
know,
have other legal remedies that
you
you
have
can.
to go a little further, but hopefully they will most of the time.
Yes.
Every now and then, especially if a landlord really doesn't want an animal on the property, they may kick back a little bit, but eventually I think they relent and do what they should be doing. But in the case that they don't, that may be a case where you need to
escalate it.
You may need to file a complaint
HUD
with
or
PHRC or HUD.
or basically fair housing. Not us, the federal fair housing.
Well, that would be HUD.
Okay, HUD. Yes.
Yeah.
Okay.
Or PHRC. Okay, so let's go on to the next question. Infestation. Is a landlord or tenant responsible for pest control? Which person?
Technically, it's the landlord, and the reason for this is that there's a implied and unimplied writ of habitability that's in Pennsylvania. So even if it's not in the lease, the landlord has to make sure when he rents your property, it is free from pests. Okay, he is responsible for that. He has to guarantee that. Okay, if you basically rent an apartment from or a property from a person and you see it's got rodents, and you still do it, then you're basically, I wouldn't do that if I was you. Okay, it is the landlord's responsibility to guarantee pest control. Okay, now he can do that, and he can make recommendations to you as a tenant, saying, okay, here's the rules for making sure that we don't get reinfested. Okay, and and again, if he posts those rules to you, you have to live by those things, or you could incur the cost of the next visit for pest control. But normally, pest control, not normally, it is the responsibility of the landlord. And the only way you will be held responsible for it is if you basically fail to live up to your obligations of a tenant. Mm-hmm. Okay, to basically guarantee there's no trash laying around, your trash is taken out. Once you get infested, it sometimes takes some time to clear the infestation. If you're in an apartment, multi-unit apartment, you can take care of yours, and it's the same landlord, but because of it happening, you can get bleed over from any adjacent property. Okay, it is still a landlord's responsibility guaranteed to protect you against that. But again, once he gives you notice of what he has to do, you have to basically accommodate that, which means that's for inspection, being able to be entered a place to basically provide some type of extermination, okay, or removal. I had a person who had a squirrel in his room and it was responsibility for the landlord to cage it and get rid of the squirrel, not to go up with a gun and shoot him over and stand that. That would have been in trouble. Okay, he had to call Humane Society to basically go up and get the animal out. Okay, just couldn't execute the animal, but for a 6-legged, 8-legged type of variety of pests, it's the landlord's responsibility to guarantee that. Okay.
Right. So you should probably also check with your municipality
Yes.
Because there may be a difference between multi-unit
Yes.
buildings and single-family houses.
Right. If it's multi-unit, most of the times, if it's pest control, they're going to basically take anything that's adjacent to that unit, and they're going to have to do all the units at one time. Okay.
Right.
And again, I know over at Hall Manor they do that when they go for pest control. They take the entire row out. Okay. They notify everybody and they do the entire row because.
Well, that's public housing.
Yes.
Okay, which may be different also again from a private landlord that has a multi-unit
But
home housing, and also a private landlord that rents out single-family homes. And who's responsible then? So you may want to check with your codes department if you're living in a single-family house. Contact your municipal codes department
Yes.
and find out who is responsible for infestation. If it's acute infestation and it's occurred, you see evidence of it when you're walking through it. Otherwise, it's nice, but you're like, hey, this seems to have had mice issues. Can you exterminate before we move in? Or even if you don't, can you do some treatments before I move in? And then you can go from there. But a lot of times it's also in the lease. Now, is the lease correct? Not violating your rights. A lot of times the leases, of course, are very heavily
favored towards the landlord, but not
landlord,
the Landlord Tenant Act 1951 puts the responsibility back to the landlord.
Mm-hmm.
It was modified in 2010 to enforce that. It was also remodified in 2014 to put some more teeth into that. It is the landlord's responsibility to guarantee your place is not infested with vermin or any type or anything that's unwanted.
Is that multi-unit, single-family home, acute infestations?
It falls under
that happened before you came in. I can see the difference between before you move in and treatments, and after you move in, and a certain period of time after you move in.
It falls under the room habitability and explicit, implied. It's every unit that's rented in the state of Pennsylvania. There's an implied writ of habitability, and one of the things an implied writ of habitability says is you're free from pest. You're from pest infestation. You are free. Okay, so it's the landlord putting in his lease all he wants. That implied habitability, that implied writ of habitability will take precedent over top of anything else. So if you got infestation and it happened, the landlord is responsible for basically writing a remedy for that. Okay.
I would say, like in most cases, when we're talking about, issues that kind of touch on the law or are the law, it all depends.
It depends on who you're going for.
It depends on your personal circumstances and what is going on under the circumstances that you find
yourself in. Bed bugs could be a perfect example. I went away, came back. I stayed in a nice ritzy hotel, Hilton. I came back, and by the way, I came back home and I brought bed bugs with me. Is that the responsibility of the landlord, or is it the tenant? Well, I'm going to ask the question. Were there bed bugs before you left? No. There's bed bugs when you came home? Yes. Nobody else have come into your place other than you. You're probably going to have to work out something with the landlord to share the costs of whatever pest remediation is going to have to be needed. Okay, but it's not at that point in time. The circumstances caused that. The circumstances was that it was pest free. You came back from a trip and you brought the pest with you. Okay, and if you can prove, and if the landlord can prove that, then you're probably going to have to pay for the pest remediation. Okay, but it's something you need to work out. I don't think a lease has that built. I don't think somebody built that into a lease, travel requirements. But it would be something that two people get together, you sit down and talk. Excuse me, there's bed bugs here. Well, when I rented this place, it didn't have any beds in it. So where did the bed bugs come? Did they come in the door with me? Did they deliver themselves? I understand. You can give me a recommendation of a pest control person that can basically help me alleviate the issue. But the landlord should not be held liable for guaranteeing that, because again, he didn't cause the infestation and do normal inactions of the tenant. That's what caused it. Okay, and when that happens, a lot of times it's notify the landlord, notify him in writing, and see how much leeway he wants to give you. And that's what it is. It's basically an art of negotiation.
Right.
Okay.
And that's one of the reasons why we're here, right? Because the first question that we talked about today was, does a landlord have the ability to refuse my ESA? Under, as a disability, you have the right to the ESA or the service animal. So that's pretty cut and dry, right? But then we move on to pest control, and things get a little bit more murky, and really depends on circumstances, and also the lease. And so
your relationship with your landlord.
And
right. If you're constantly beating the landlord over the head with the letter of the law, be careful. It works in the other way too. The landlord can basically use the letter of the law. That's where you better make sure you have an ironclad lease, because he could use that lease and the letter of the law to cause you some discomfort. So you want to know.
Even if most contracts are pretty ironclad, like we already mentioned, it's the landlord's lease, so it's going to be skewed towards the benefit of the landlord.
Right.
But as adults, we do have the capability of, talking back and forth and trying to come to a fair and reasonable resolution. And that's part of what we do here is, before you go to the court, we're not attorneys, but we do, discuss and try to help people to move through these kinds of issues every day. So before you call an attorney, it normally makes the landlords upset when you start bringing legal cases into the situation. Then give us a call and see if we can at least try to help. But there's only so far we can go. But we can, if you give us a call first, then maybe we can help you to move through these
Not
issues.
Attorneys, but remediation, sitting down with some dialogue will help. Okay, the law, always treat the law as a nuclear option. Always treat the law as a nuclear option. When you exercise it, that means that you're not playing anymore. You're not playing anything. You're not willing to talk anything. You want something done. It's immediate. And it could work in your favor and work against you. I always said what works in the landlord's favor is, and we talk about this, Rhonda, a lot, the notice to quit. If it's in your lease, be careful, because it works. That gives whoever wields it a certain amount of ability to exercise. Okay, if the landlord has it, he could basically say, well, I can break this lease because notice to quit allows me to do it because you're a pain in the posterior. So goodbye.
And thank you for bringing that up, because we're going to be talking about the eviction process and another session of discussion of Ask the Counselor. Because of course, especially nowadays with the rent going up and all kinds of issues with affordability, we get, there's all kinds of different aspects of the eviction process that we need to talk to residents about just about every day. I don't think there's a day that goes by when we don't talk about.
I have people ask me a lot of times about evictions. Yes.
Right. Yeah. So that may be a whole by itself.
Yes.
Right. So let's move on to our last question. Is this one okay? So this one is kind of home ownership, but it's also rental. And I thought it was an interesting question, and something that sometimes people need to take into consideration when you're a renter and you're about to purchase a home. So like we always say, timing is everything, right? So here's the last question for today. I'm closing on a home in a few days, and I still have 6 months on my lease. My landlord says I must pay the rest of the lease term. So that was 6 months of rent that needs to be paid.
Yep. And
All at once because you want to terminate the lease 6 months in or however many months in, and to move into your new home.
Okay.
So what rights would a tenant have under those kind of circumstances?
And we just talked about this a little bit earlier. Notice to quit.
Mm-hmm.
That's your out clause. If there's an out notice to quit, then there's a timetable associated when that notice has to be presented back to
It's
everyone.
usually an early termination notice.
No, there's
Early termination.
There's an early termination notice, but it's also it's explicitly a notice to quit. If that verbiage is in your lease, review it, because that's your outcome. And normally it's notice to quit. It'll have specific reasons that you can exercise that
Okay.
notice to quit.
Now, okay. So normally when I see notice to quit in a lease,
Mm-hmm.
it's on the landlord side where they say if you breach the lease in some way, then we will give you 3 days or 10 days or 5 days, or you waive your notice to quit altogether. If if they say you waive your notice to quit and you sign the lease, then you get no notice. They just go straight to the eviction, to landlord tenant court and file. But that's normally where I see the notice to quit coming in. Now on the tenant side, I will see, I'm moving, I don't like it here, or I purchased a home. I know, I still have 6 months on this lease, but I want to terminate early, and a lot of times we'll see early termination in 30 days. You have to, prior to terminating lease, or 60 days.
Yes, it's 30 for notice to quit. If the lease is less than a year, 15 days notice.
That's for the landlord.
Landlord. Or it would say landlord. It's basically 15 days. If the lease is older than a year, it's 30 days.
Okay, so
that's just a pure notice to quit. The early termination.
That's breach the lease. I'm giving you 10 days to leave the premises. If you don't leave within 10 days, then I'm going to take you to landlord-tenant court.
That's right.
Right.
Yes.
Now that doesn't normally work on the tenant side, though. They're not going to give them a 10-day notice to quit that I'm leaving at the.
No,
they're terminating the lease early.
Right. If you don't have if there's no termination language inside the lease, the tenant, you could be on the hook for 6 months worth of rent. Because it's at that point in time, it's a contract. You're breaking the contract.
Right.
Okay. So they could take you to some I would call it small claims court, but they would bring you in front of somebody like me, and you broke the contract. You owe 6 months. It's not a question of rent. It's a contract. You're breaking this contract. What's the reason for breaking the contract? And closing on a home it sounds good. Is there any legality behind that? No. There's no. If I'm gonna close 6 months, I have 6 months left on my lease, but I'm closing 6 months early from my house, then I'm still on the hook for that 6 months.
Right, and the way that our counselors usually explain that is because if you look at your lease, it will tell you what you pay. If you have a year lease, it will tell you how much you're paying in total for that contract. That's how much. That's how much you owe the landlord for staying in that unit. And it's just broken down monthly, sort of like your car insurance. Yes. You owe, $5,000 a year, but you pay it monthly. Or $2,500 every 6 months.
I'd also say something too. If let's say the landlord said, "I'm gonna let you out of your lease," get it in writing. Do not take his oral response. Put it in writing and make sure he signs it, because again, you may get out of you may find you've gotten out of your tenant lease, and you may find now contract law comes in and bites you in the rear end.
You still owe that 6 months.
Yes.
And that's what we normally see. Tenants will come and come back to us and say, well, the landlord said that it's fine for me to early terminate. I gave him the proper notice. I gave him the 30 days or the 60 days, and the landlord came back and said, fine. The landlord is not in the business of making you stay anywhere.
No.
Normally, they're going to say, okay, you can terminate early, but you still owe me the rest of this contract.
It becomes a contract at that point in time.
Well, it's a contract the day that you sign it.
Yes.
At least it's a contract.
Right, but the tenant landlord rules won't protect you at that point in time.
No, if it's in that lease that you owe this amount of money, normally you're going to have to pay that amount of money for that year. And now, if you're month to month, then in that case, that's different.
But if it's a year, it's for
in that case, you may have the 10-day, 15-day notice to quit.
And that's what you get out.
That's when
notice
it
to quit will come in at that point.
Right. Because basically every month, if you're month to month, your lease renews every month.
For the term that was initially stated. Okay? If no term was stated, and this is a catchy part or touchy part. When you take the lease, if you didn't have a term stated, then it's implied month to month. It could be implied a year. You've got to make sure how, and if they compute your cost for a month, then it's a month to month lease. If they compute the cost at a year and divide it by 12, you got a year's lease. That's how, and that's a little catchy. They will catch you like that.
We have seen that.
Okay.
And so the question that is always presented is this a year lease or is it actually a month to month? And a lot of times the landlord will do exactly that, which makes it
look at the dollars that are stated, and
it's for a year.
Yes, and divided by 12, and if the
for
numbers
the monthly payable and so what is that? So and that makes a whole lot of difference, especially if they want to raise your rent. Mm-hmm. That's normally where we get questions about, can they raise my rent after I just moved in here? Mm-hmm. And the landlord says, no, you have a month-to-month rent. But they put the whole year in there.
That's a year's
now
lease.
If they put the total amount for the year in there, then the tenant's argument could be, well, the contract is for a whole year. You put the whole year in there. It's an annual lease.
Yep.
The landlord's position is always going to be no. It says month to month. It says month to month, so I can raise it. So it can get messy. So again,
yes.
Like we say, it all depends. So
it also depends on the judge you go in front of too.
Right.
Okay,
right.
Because again, if I see it as you may think it's month to month, but it's a year's, mm-hmm. then Mr. Landlord, I don't want to see you for a year. Okay, mm-hmm. 60 days before that lease, before the lease terminates, or 10 months from now, I'll see you. Okay,
right.
And you at that point in time, it's your option. You can say I'm not going to renew it, or there's a new amount that you can put down. It's a new lease at that point in time. Mm-hmm. Okay, but if you don't show up, and sometimes people forget this. They don't show up. They show up 15 days before the end of the year. Well, guess what? They just got renewed. That lease is going to be renewed for another year, not month to month. It's going to be for whatever the terms was set in the original lease.
Right.
Okay.
Because you normally have to get 60-day notice.
Yes. I always call it not even lease and contracts. Auto renew clauses. My days of corporate America, I used to companies hated me for this because I had a red pen. And as soon as I saw anything that said auto renew, red pen came out and I erased. No, we don't automatically renew anything. When it comes time for this contract to be over, you can come back and talk to me. You get a chance to sell me again.
Right.
And that's the way you can do that. That's the way I would do even tenant landlord. Be careful with the automatic renew. If you strike it out, and year comes up, he can basically come back and say, well, your lease is up. It didn't auto renew because you deleted that clause. Now your rent's going to be XYZ. So be careful when you're going to do things like if you're going to ignore the renewal clause.
Well, that a lot of times in the lease it'll say that after this year is up, then you automatically convert to a month to month.
I'd also watch that too, because again, you give it to me for a year, the first year for a year, but then after that, now it's month to month. You're at the discretion of that landlord at that point, because you're there for a year, but he decides when it goes to renew it, the next month it's going to be month to month, and I'm going to increase your rent. Okay.
Right. At any time they can increase your rent with a month notice. Yeah, with the proper notice. So. Yeah, unless you are going to be there for a limited period of time, like in this person's case where, they're purchasing a home, and anytime within that, 6 months, they could be moving into their new home, and they know that, then it might be worthwhile to go to a month to month. But normally you want to lock in so that you know every month how much you need to pay, because otherwise, the rent increases could happen and other changes to the.
I would go back and say, if you're going to buy a home, if you're looking to buy a home later on this year, and you're on a annual lease, you basically want to hold up if you can and get it converted to month to month.
Yeah, if you can. If not, try to time it so that you're closing on it at the end of your lease, and give your landlord the proper notification.
Yeah. Don't just walk away from it. You will, because you may be getting a new home, and you may have a lien against that new home before you get a chance to move into it. Okay, because they'll say take it to civil court, and if you basically found negligent there, then you're going to have to pay.
Right. I mean, rents are up. They've gone up so much. Some people, have like $1,300, $1,400, $1,500 a month rent, maybe $2,000, and you add that up over 6 months. Plus, you just put all of this money down on a house. That's not a good way to start out as a homeowner with that obligation on you. So, timing is everything. So. We covered a lot today.
I guess the next one want to do eviction. The entire process, I think it will take an hour, but
we don't have an hour.
Yeah, well, whatever time we have, there's a checklist that for an eviction to take place, there's something the landlord has to do, there's something that the courts will do, and I didn't put the tenant there first. It starts with the landlord, then goes to the courts, and then the tenant gets involved. And tail end, okay? The tenant has to be served. No service, no eviction. Okay, simple as that. That's key. Second thing, for evictions, you will have a hearing. There is no default decisions. Okay, a normal contract or civil, if somebody doesn't show up, they lost the case. Simple as that. For tenant landlord, the landlord or his agent must show up. Okay, if the tenant doesn't show up, that doesn't necessarily mean he's going to get evicted. Okay, landlord and the agent has to present their case. Okay, there's no default judgments. That's the only place where there's no default judgment at.
Well, that's a good preview of what were the kind of things that we're going to be discussing. Pretty much the process, what you can expect, and the if-then scenarios of evictions. But I think we're going to end it here. Okay. And I'm looking forward to that discussion. Now, I always need to make this disclaimer. I should have made it in the beginning and the end, but here it is right now. The Fair Housing Council of the Capital Region staff and agents are not attorneys. Our discussion here or at any time, even when you come in for one-to-one counseling or group counseling, is not meant to be legal advice. If you need legal advice, then by all means, contact an attorney, and they will be able to assist you legally. But we do not. Everything here is advice, information, rights and responsibilities.
And since this is civil law, public defender can't help you. Okay, public defender is only for criminal cases. Okay, civil cases, no, you go to legal aid. If I think we have legal aid, but from a judge's standpoint, if you appear in front of me without legal representation in a civil case, I can still hear the case. You're not entitled to legal representation, not on civil, only on criminal. Any place where you can lose your freedom, you have to be represented by a legal representative. For civil matters, no. Civil matters, you can go find whatever agency that can provide you with that, and it's basic legal aid in Pennsylvania. They're about, or anybody who will do pro bono work who can basically provide you with that, or you want to pay for it. Fair housing, we do not. We're not attorneys. I do not give legal advice. I quote you what the law will tell you. As a certified district judge, that's as far as I can go. Okay, but I can tell you what the parameters of the law are going to be. Can't tell you how to decide anything. It's going to be, here's what the law says, here's the burden of proof, and again, in most civil matters, the burden of proof is preponderance of evidence. The person who brings the most evidence will win the case, always. That's it.
Okay, well, that's it for us, and I appreciate your engagement and in these housing conversations, and I hope the public receives some news they can use and some information that is useful as they try to navigate the housing situation within our communities right now. So
thank you.
Until next time.
Bye-bye.
Thank you. Bye-bye.